A court just made a ruling involving the Second Amendment that could have huge implications nationwide. Let's get into it. Have you ever wondered how someone can be old enough to join the military or vote in elections or sign legal contracts, but still be denied the right to carry a firearm for self-defense? Well, a Florida court just answered that question in a way that could send shockwaves across the country. And what happened next may actually surprise you. My name is James, and welcome back to the 2A Defense Network. A major court ruling out of Florida could have massive implications for Second Amendment rights nationwide, especially for millions of Americans between the ages of 18 and 20. In June of 2026, Florida's 4th District Court of Appeals struck down a state law that prohibited legal adults between the ages of 18 and 20 from carrying a concealed firearm. Not only did they rule that the law was unconstitutional, but it also vacated a conviction of a young adult who had been prosecuted under that very law. And that is a massive development. But here is where things get even more interesting. The judges, they didn't simply just focus on firearms. They also focused on adulthood itself. The court pointed out that 18 to 20-year-olds can vote, they can sign contracts, they can serve in the military, and they can even be sent overseas to defend this nation. So the court asked a very important question. If these individuals are recognized as adults for so many constitutional and legal purposes, why should they be treated differently whenever it comes to exercising a constitutional right? The court ultimately concluded that adults between the age of 18 and 20 are part of we the people, protected by the Constitution. And that reasoning could have consequences far beyond Florida. Now, if you've been following Second Amendment cases over the last few years, you've probably heard of the Supreme Court's decision in New York State and Rifle and Pistol Association versus Bruen. That case changed the legal landscape by requiring governments to justify firearm restrictions through historical tradition and constitutional text. Since Bruen, courts across the country have been reevaluating gun laws that were once considered untouchable. Age-based restrictions have become one of the biggest battlegrounds, and this Florida decision just added another major ruling to that growing list. But there is something that the headlines has been leaving out considering this case. Even though this ruling affects concealed carry rights, Florida still generally prohibits firearm purchases by individuals under the age of 21. Yes, that makes absolutely no sense. An 18-year-old may now be legally allowed to carry a handgun under this ruling, but may still face restrictions on purchasing one directly. And that creates a legal situation that raises questions throughout the firearms community. How can someone legally carry something they may have limited options to legally purchase? And that's a question courts may eventually have to address as additional lawsuits move through the legal system. So, with that being said, let's talk about what happens next. Normally, after a major appellate court decision like this, you would expect the state to appeal, but that's not what happened here. Florida Attorney General James Uthmere announced that his office would not defend the restriction and would not seek further review. In other words, the state is not currently appealing the decision. That means the ruling remains in effect unless future litigation or legislative action changes things. However, there is still some uncertainty. State officials have indicated that they're working to comply with the court's decision, but there has not been a statewide timeline announced for updating procedures, law enforcement guidance, or administrative policies. So while the ruling is significant, questions remain about how quickly it will be implemented across the state. And that's where this story becomes even bigger than Florida. Other states with similar age-based firearm restrictions are watching these cases very closely. Attorneys challenging those laws may now point to this ruling as persuasive authority. Will other courts agree? And that is the big major question moving forward. What we do know is that the debate over whether legal adults aged 18 to 20 should enjoy the same Second Amendment protections as older adults, it's far from over. In fact, the decision may only be the beginning. So, let me ask you, if someone is legally considered an adult at 18, should they have the same Second Amendment rights as every other adult? Should they be able to purchase a firearm if they are legally allowed to carry now? Or should states be allowed to impose age-based restrictions? Let me know down in the comment section below. If you enjoyed this update and you want more coverage of major Second Amendment cases from around the country, make sure you hit that like button, subscribe to the 2A Defense Network, and turn on notifications so you do not miss the next video. Because legal battles shaping the future of the Second Amendment are happening right now, and we will be here covering them every single step of the way. So, until next time, see you later.